long-haired weirdos, short-haired weirdos, vandals, hooligans.
The government, hug the government, love the government, hug the government, love the government, hug the government.
Welcome to The Politics Guys, a place for bipartisan, rational, and civil debate on American politics and policy. I'm Trey Orndorff, a political scientist at Oklahoma Christian University, and I'm joined by Ken Katkin, a professor of law at Chase Law School. Ken, welcome to our ongoing midweek supporters-exclusive Constitution show.
Oh, it is great to be back.
You know, we've had a little bit of a hiatus from doing the Constitution show just because of schedules and graduations. But, you know, we're closing in, I think, on the next milestone, which is the completion of the Bill of Rights, right? So by the end of last year, we had finished the actual constitutional text itself, which I thought was a big accomplishment all by itself. And we've continued to move forward. And here today, we're going to take on the 7th and the 8th Amendments. And then that means we'll have one more show where in combination, we're going to do the 9th and 10th. And we'll have finished then up the Bill of Rights. And so I'm really excited now to have this kind of whole piece to be done. Now, we're not going to be done all the way. Never fear. Ken and I are going to continue through the Constitution and the remainder of the Constitution. Although it's kind of hard for me now to predict how much longer that portion will take. I don't know, right? That's not a part that I teach a lot of kids.
The three Civil War amendments, I think, could take us some time. And then we're going to push all the way to number 27. But I think other than the Civil War amendments, there's probably only 2 or 3 that will take us any significant time after we get past the 10th Amendment.
And then who knows what we will do next. And so one of the things I just wanted to say for those of you, if you are listening right now, you might want to think, what would you like Ken and I to do? I know Mike and Jay, they're boring, right? They just do more stories for the midweek show. I tease. They do a lot of fun stuff. But Ken and I, we have gone kind of this different direction. I really loved it. So we would love for you, if you're part of our Discord group, to head out to Discord or to email us at mail@politicsguys.com or to get us on social media, either on X and Facebook. You'll find all those in the show notes. And let us know. Start talking to us now because it takes some prep. Let Ken and I know now, what would you like us to cover next? So, Ken, with that kind of down and out of the way, why don't we move on to the 7th Amendment? And the 7th Amendment, this is probably not going to take us quite as much time, but as we always do, we'll start with the text of it. And it says this: in suits at common law where the value in controversy shall exceed $20, the right of trial by jury shall be preserved, and no fact tried by a jury shall be otherwise re-examined in any court of the United States than according to the rules of common law. Now, for us, there's a lot of things here, and I think oftentimes my students gravitate towards this one if for no other reason than they see $20 and they just think, $20, I have that in my shoe. What does it even matter? Like, I don't understand. But it actually was, the 7th Amendment was a bigger deal than you might think during the Constitutional Conventions. As a matter of fact, the records show that during the Constitutional Conventions, delegates twice raised the issue of whether the Constitution itself should have a right to a jury trial. Matter of fact, towards the end of the convention, Hugh Williamson, who is of North Carolina, observed that there had not yet been any provision for, in his words, juries in civil cases, and suggested the necessity of it, end quote. And so there had been some support for this. And the reason for it is that there's an idea that you need to have citizens dealing with these those goes. Now the problem though was, and this is kind of common, we talked about this in the earlier portions of the Constitution. Opponents were worried that if you mandated civil jury trials, that this would end up being problematic in criminal cases. So much so that actually Alexander Hamilton brings it up in the Federalist Papers. And again, this actually dates back to English common law. So Ken, how much, again, I know all the history of this, and I could talk about that for a good long while, but does any of that have some ramifications for us? What does the 7th Amendment mean for us today, outside the fact that obviously it was important at the convention, it's important in the immediate aftermath? Does Tull versus the United States, how much does that really do much for us here in contemporary America?
I think the Seventh Amendment is mostly a dead letter today. There's really almost no cases where someone raises a claim that their Seventh Amendment rights were violated, and that turns out to be a winning claim. It's one of the few rights in the Bill of Rights that's never even been incorporated against state and local governments, so it doesn't apply to state court proceedings or local court proceedings, although most state constitutions have their own rights to jury trial in their own state courts. Yeah, it may have been a little bit more of a big deal at the convention than it turned out to be. One of the other things I'd say about at the time of the convention is it was a somewhat theoretical discussion because they actually punted the question of whether there would in fact be any federal trial courts, right?
Yeah.
So the Seventh Amendment requires that there be jury trials at least some of the time in federal trials, but it doesn't actually. The Constitution doesn't create any federal trial courts. They left that to later Congresses to decide whether to do that or not. Although we've always had them since the first Congress. We've had federal trial courts.
Well, and that's worth mentioning. We've talked about this. It has been a while ago, right? Article 3 of the Constitution, which deals with courts, it indicates that you're going to have a Supreme Court. That it outlines kind of the broad jurisdiction of that court, and that's pretty much it. The rest of it is an empowering of Congress to make potential decisions about what a court system would look like. And you're right. One of the weird things about it, and the Seventh Amendment's example of it, is it says, okay, that thing that we didn't do, if you have it, this is what it's got to do.
Yeah. And it's filled with kind of technical terms of art that are mostly really loopholes. So, the first few words that you read in suits at common law, to a modern reader, that probably sounds like most suits, but, coming out of English legal practice, they used to distinguish between common law, courts of common law and courts of equity. Mm-hmm. So a lot of lawsuits would be brought in courts of equity, maybe the equivalent of what today we might think of as small claims courts. And just like small claims courts today don't use juries, equity courts never use juries, and the limitation to suits at common law is sort of meant to delineate that line, although it doesn't really give much of a definition of what kind of cause of action can be brought in a court of equity and what kind of civil action has to be brought in a court of law. The $20 exclusion similarly would have necessarily accepted more cause of action then, although I think even then most lawsuits probably would have been for more than $20. I looked on an inflation calculator, and it's hard to know how accurate those things are when you go that far back, but this would be something like $420 today. So I think most people today don't file lawsuits for less than $420. So
if you want another little one, because it's funny that you did the inflation calculator. I did a little bit of history. They put it, if you don't do it in calculator, but you do kind of like equivalent purchasing power metrics, that you get it somewhere about just about $1,000 or a little under $1,000. So in the ballpark.
So that's more. Yeah. So maybe that's more accurate. I was thinking that I was surprised that it would have only been a multiple of 21, I guess. And then the right of trial by jury shall be preserved. Again, preserved is kind of a way of saying you don't have to have it in the types of cases that they wouldn't have had it before, which might be quite a lot of cases, but you do have to have it in the kinds of cases where they would have had it before. So even there's kind of I think a lot of the language that sounds kind of generic or anodyne is actually signaling different kinds of exceptions or loopholes where this wouldn't apply. You've got the reconsideration clause or reexamination clause. No fact tried by a jury shall otherwise be reexamined in a court of the United States. That, has never, I don't know what the framers thought that would mean, but it has never really had much meaning because we've always had a practice where judges are allowed to give directed verdicts where in a civil case, they can just rule in favor of one party or the other without letting it reach the jury, even if a jury's sitting there. Or they can give what's called a judgment notwithstanding the verdict, where even if the jury gives a verdict, the judge can enter judgment that's the opposite of what the jury decided. That's always been a part of our civil practice, and it still is. So really, it's a pretty minimal right. The other thing I would say that's more a modern thing about it that wasn't really an issue at the time of the framers, but is a very big issue today, is that in the federal rules of civil procedure that are used in civil cases in federal courts, there are a lot of mechanisms for preventing trials from going to jury, and almost no civil trials do go to a jury. So you're talking about 96, 97% of civil cases that are filed that never reach a jury, and that's because along the path to getting to a jury, first there's kind of mandatory recommendation that the parties use some kind of alternative dispute mechanism to settle the case. So they may be referred to go to mediation or even arbitration before they can come back to court and say we couldn't settle it. Then there's a mechanism called motion to dismiss and a mechanism called summary judgment. They're different from each other, but they're related. So in motion to dismiss, if the plaintiff files a complaint, the defendant can file a piece of paper that says, even if everything they've pled in that complaint is true, there's no legal basis for entering a judgment against me, so this case should be dismissed right now. That's not used that frequently, but it's sometimes used, and so some cases will get dismissed right there. They'll never get to a jury. What's a lot more common is this mechanism called summary judgment, where the plaintiff files a complaint, and the judge says, okay, the parties can start a process of discovery, so they can examine each other's documents, they can depose each other. We'll start this case, we'll start this litigation, but this is all before it would reach a jury. This is pretrial litigation, and after the discovery process is over, but before we reach a jury, either party can file a motion for summary judgment and say, well, now that we've done discovery, now that we've collected a bunch of evidence, the court should just decide the case right now and not let it go to a jury, and that's used very frequently. So there really are many mechanisms in modern civil litigation where cases are kind of disposed of before they can actually reach juries.
So the only one that when I take a look at this and we talk about this that comes up in my area, as I had mentioned a minute ago, and so I was curious, was cases that surround, in the contemporary era, we have a lot of what we call kind of administrative law colloquially, but where you can have entities that are liable for civil penalties under things, say, like the Clean Water Act. But that's then part of the administrator of the EPA, the Environmental Protection Agency, to initiate in a court. And so you have cases like Tall versus the United States, where you have to sort out, does that count as a case that requires a jury? Do we have any others that deal in that kind of vein? I know that was one area that we take a look at a little bit for things that I do.
Yeah, so that's right. That's a good point. There's a couple lines of cases related to what you're talking about. So one is a lot of regulation by administrative agencies of different types of business entities generally. The agencies typically will have, if you're talking about a regulated industry, the agencies will have authority to promulgate regulatory rules that the regulated entities have to comply with. And then the same agencies will have enforcement arms that can monitor whether the entities are complying with the rules or can respond to complaints if someone complains that a regulated entity isn't complying with a rule. And then sometimes there will be hearings. In my profession in the law, that's very common, right? So lawyers are licensed. Lawyers have rules of professional conduct. And if somebody complains that their lawyer violated the rule of professional conduct and that their license ought to be suspended or they ought to be disbarred, then that's probably going to happen at an administrative hearing before a court or a bar association, but it's not going to happen at a jury trial. And, by and large, there's a doctrine called the public rights doctrine, which is just another one of these things that has turned the Seventh Amendment into a bit of a dead letter that says if people have a right that they only have because the government gave it to them. They have some kind of license or some kind of generally I'd say a license, but it could be something like someone's been admitted to a public university as a student, and now they're going to be suspended or disbarred, but they're kind of or just suspended from school or expelled. Someone's taking advantage of some privilege that the government has given them under some license that the government has given them. That's often conceptualized as a public right, and so if it's conditional, right? If you can only be a lawyer as long as you comply with the rules of professional responsibility, you can only be a student in a public university as long as you make good enough grades to stay in good academic standing and don't violate the disciplinary rules. Then typically it's okay in the first instance if there's an allegation that you haven't met those conditions. That there'd be an administrative hearing, which wouldn't be a jury trial, where a dispute can be adjudicated. Now, in all of those situations, there's always judicial review to appellate courts. So you're never at the end of the line in those administrative hearings. There's always recourse to courts, but not to jury trials always, right? Sometimes the courts will review the record that was made in the administrative hearing and not offer an opportunity for a jury trial. I think that's never been thought problematic under this public rights doctrine, but there has been a little bit of noise in some recent, the U.S. Supreme Court, a lot of the recent opinions have been much more skeptical of administrative law and administrative procedure than was the case in the 100 years before this. And I wouldn't be shocked if we end up seeing a Seventh Amendment case come up there.
Okay. Yeah. Well, that was one of the reasons I had brought up Tall. I had wondered a little bit about that. Now, I know we have more here to talk about, Ken, but I need to pause us there because this actually ends our ad-supported preview of our supporters exclusive midweek show. So Ken and I are going to be finishing up, and we're going to do a lot because I think the big amount of what we're doing here is going to be the Eighth Amendment with cruel and unusual punishment. I'd love for you, if you're listening, to be a part of that conversation. But if you want to be a part of that conversation, you're going to have to become a member of the Politics Guys, a supporter of the Politics Guys. And it's really easy to do. All you have to do is head over to patreon.com/politicsguys. Again, head over to patreon.com/politicsguys, and you're going to see all different kinds of levels of support, which includes all of those levels of support. That gets you the midweek show. So if you want to continue on with our conversation here of the Seventh and the Eighth Amendments, you're going to need to head to patreon.com/politicsguys and select the level of your support. Now, but look carefully because there's all different kinds of things you get, including our very active Discord group that I've talked about probably too much sometimes. But don't forget that you also get some other fun things when you become a supporter, including, we talked about at the beginning of the show, the fact that Ken and I have been doing this, well over a year now. All of those shows, everything that we do is available to you as soon as you become a supporter. So it's not like you're just getting one show. You're getting numerous shows when you become a supporter of the Politics Guys. So again, head to patreon.com/politicsguys. You can support us in a variety of other ways. We're on Venmo, where we're at Politics Guys. You can also support the show through PayPal. All of those support links are in our show notes. And if you want to, you can always head to politicsguys.com/support to make that happen. Now, if you're not in a financial position to become a supporter of the Politics Guys, but you do want to finish up this discussion with us, well, listen, I understand. Please just reach out at mail@politicsguys.com and we can get you set up. Now, whether you're a supporter or not, don't forget you can always rate and subscribe to us on the podcast app of your choice, and that makes a big deal. We'd love to interact with you on Facebook, Twitter, or even an email. You can email us at mail@politicsguys.com, and you can get all of our other links in those show notes. The executive producers of the Politics Guys are Bruce Johnson, Wilma Marino, Daniel Toe, Ryan Beasley, and Don Oglesby. We'll be back with a new episode this weekend, and I hope you'll join us then.
This podcast is part of the Democracy Group,